Good afternoon, everybody. Welcome to the Faculty of Law. Before listening to our keynote, Judge Chile Eboe-Osuji, we have a few words of welcome of Professor Andrea Olesti, the Dean of the Faculty. The floor is yours.
Good afternoon, everybody. It's an honor and a privilege to extend the warmest welcome to the Faculty of Law of our University of Barcelona. On behalf of the entire faculty, I want to express our sincere joy in having you here with us today. It's a great pleasure that it's with a great pleasure that I extend a warm welcome to all participants at the 16th biennial meeting of the International Association of Genocide Scholars. I want to express our sincere delight in hosting this respected gathering of scholars, researchers, and practitioners dedicated to the study and prevention of genocide. It is with great pleasure and immense pride that I extend a sincere welcome to our Faculty of Law. Our city, Barcelona is our city, offers a vibrant and a culturally rich backdrop for this gathering, with its captivating history, with its architectural wonders, I would say, and diverse scenes. Barcelona is sure to provide you an inspiring and enjoyable environment for both intellectual exploration and social intelligence. We wish the faculty, wish you all an inspiring and rewarding meeting. Make the most of this unique experience and return home with new knowledge, renewed perspectives, and unforgettable memories. Welcome to the University of Barcelona.
Thank you, Mr. Dean. So this afternoon, I'm very happy to have here with us Judge Chile Eboe-Osuji, who we met in Armenia a few months ago, and when we spoke about the conference, he's like, oh, I would like to come. So I said, you're welcome. And here he is. He will be speaking about quantifying genocidal intent, an object lesson in imprudence. But before that, I'm going to introduce him, his trajectory. Judge Chile Eboe-Osuji was the 4th president of the International Criminal Court. He's the Distinguished International Jurist at the Lincoln Alexander School of Law at the Toronto Metropolitan University and a special advisor to the president of the university in Canada. From 2012 to 2021, he served as a judge at the ICC, first as a trial judge and eventually as an appellate judge. Prior to joining the ICC, Dr. Eboe-Osuji served as a legal advisor to the United Nations High Commissioner for Human Rights in Geneva. Earlier in his career, he worked at the International Criminal Tribunal for Rwanda and at the Special Court for Sierra Leone as a senior prosecution counsel. Before joining the International Public Service, he practiced law as a barrister in Canada, his adoptive country, and Nigeria, his birth country. Following the end of his tenure at the ICC, he has also served in the following visiting professorships: the Paul Martin Senior Professor of Political Science, International Relations and Law at the University of Windsor, Visiting Professor of Law at the University of California, Los Angeles, the Herman Pledger Visiting Professor of Law at the Stanford University Law School, Distinguished Visitor at the University of Toronto Faculty of Law, and a Senior Fellow at the Carr Center of the Harvard Kennedy School. He has also taught as a adjunct professor at the Faculty of Law of the University of Ottawa. He has received PhD from the University of Amsterdam in the Netherlands, his LLM from McGill in Canada, and his LLB degree from the University of Calabar, Nigeria. His honors include the Golden T. Butcher Medal of the American Society of International Law, a Doctor of the University degree honoris causa from the University of Middlesex in England, the gold medal of the honorary patronage of the Philosophical Society of Trinity College in Dublin, and the Chief Emeka Aneyaku Lifetime Achievement Award. He is a member of the high-level legal panel on media freedom and a senior peace fellow of the Public International Law and Policy Group, and he has an extensive record of legal scholarship, including books of international law, sexual violence and armed conflict, Protecting Humanity, and a forthcoming volume on the legal and political history of sovereignty, criminal responsibility in international law. So it's a real pleasure, and I give you the floor. Thank you.
Thank you very much, ladies and gentlemen, for inviting me. If you don't mind, I will stand. I normally would have preferred to speak from there, but because I'm going to do some presentation, the computer cannot be moved to there, so I'll do it from here. And we had to convert, pardon me? Yeah, but I cannot. Yeah. So we had to convert my slide from something else to another program. Hopefully it works, but it looks like it is. So the topic I want to speak about is something that moves into what the Undersecretary General for the UN, who's with us today, I should have acknowledged that to begin with. It started with this morning, but I'll come at it from a different perspective of certain legal developments. And the topic is quantifying genocidal intent. And I asked the question whether that attempt is an object lesson in imprudence, as in we're not careful what we're doing. Yet, let me begin with the Rwandan genocide. When we were moving today from the historic, beautiful building to here in the taxi, I was in the taxi with three professors, and one of them, Stephanie is here somewhere, I'm sure, mentioned that the Rwandan genocide next year will be the 30th anniversary of that genocide, and I hadn't thought about it until you say this. Thanks for reminding that. 30 years ago. So it was in April 1994 that genocide was happened. For 100 days, from the 6th of April 1994 to July 1994, it was stopped not by the United Nations, not by any other force, but by the military wing of the Rwandan Patriotic Front, RPF, the Rwandan Patriotic Army. They were the ones who stopped that genocide in July 1994. Now, in March 1998, President Clinton flew to Kigali and gave a speech. The text of his speech you'll see up on screen. We're not going to go through the whole thing, but let's look at some of the highlighted parts. Here, he says, I've come today to pay respect of my nation to all who suffered and who perished in the Rwandan genocide. Now let's move on. The other highlighted part says the international community, together with nations in Africa, must bear its share of responsibility for the tragedy as well. And it continues, we did not act quickly enough after the killing began. And it continues, again in the highlighted part, we did not immediately call these crimes by their rightful name, genocide. And then let us work together as a community of civilized nations to strengthen our ability to prevent and, if necessary, to stop genocide. So, here, genocide. Rwandan genocide. We did not act quickly enough after the killing began. We did not immediately call the crime by their rightful name, genocide. I have come here today pay respect to my nation. Now, what's wrong with that in terms of timelines? All right. Genocide happened in 1994. April 1994 to July 1994. And it's only in March 1998 that we're getting this apology that says, let us call that crime by its rightful name, genocide. The point is that 4 years later, do we get this acknowledgement? And that's important. In the report of the United Nations, independent expert report that investigated the failings of the UN in relation to that genocide. It was a castigating report, some of which, some of the observations there was that the United Nations failed to prevent that genocide. Remember, it was the RPA that stopped it in the end. UN failed to stop it, and there was a persistent lack of political will by member states to act, or to act with enough assertiveness, and so on and so forth. Now, when President Clinton said, well, the international community needs to bear its share of responsibility, including nations in Africa, politics can allow us to say things like that and hope to get away with it, but history done right will be more precise in its own observations. And part of those observations is there were 3 ambassadors at the UN Security Council who were fighting an uphill battle to have the United Nations Security Council recognize that genocide was happening as it was happening, and for the United Nations to increase the capacity of the military force, the UN military force in Rwanda, to stop the genocide. Those 3 ambassadors we need to recognize. One of them was Ambassador Colin Keating of New Zealand, who was the President of the Security Council in April when the genocide started. Presidents of Security Council, as you know, serve only 1 month. The next month, you had the Nigerian ambassador, Ambassador Gambari, who took over, and then tried to push a resolution of the UN Security Council to do something to stop the genocide. Another ambassador that requires recognition here was Ambassador Karel Kavanta of Czechia, of the Czech Republic. These 3 ambassadors did what they could do to move the international community, the UN, to stop the genocide, but they failed because it wasn't just to say that we failed, the President of the US at the time, to stop the genocide. It was more that there was an active resistance to recognizing that genocide was ongoing. Now, the problems, I say, that active resistance from the United States in particular to recognize genocide. Now, it's not just to say that the US has a powerful voice in the international community. What US says, other states tend to listen, even if they don't agree. But it's more that the US has a veto power in the Security Council, and when it doesn't want to move and will veto something, the UN Security Council cannot move. Now, in 1994, as of June, the US still had the ghost of Somalia that was haunting its foreign policy. You remember what happened in Somalia? The killing of US soldiers in Mogadishu. Now, as at that time, again, as the genocide was happening, there was a sense that the US had a certain sympathy with Belgium. Why? Because 10 Belgian soldiers had been killed in the course of that genocide. These were 10 soldiers who were drafted to give close protection to the Rwandan prime minister at the time, who was Tutsi, and who was killed in the airport as part of the story of the genocide. So the 10 Belgian soldiers were killed. Because of that, Belgium, that was the most robust military force within the United Nations assistant mission in Rwanda, UNAMIR, Belgium decided to pull its soldiers, its forces from Rwanda, basically leaving the UN UNAMIR inept to do anything. And not only did Belgium immediately pull its soldiers, it went to UN and started lobbying for the UN entirely to withdraw from Rwanda. And there was a sense that the United States foreign policy was sympathetic to Rwanda, to Belgium in that regard. So these are some of the unstated concerns we had. But the argument that was put forward for Americans' reluctance to accept the genocide was ongoing. You see in an exchange between the spokesperson of the US State Department, Ms. Christine Shelley, and Mr. Alan Elsner of Reuters. In an exchange you had in a press briefing that the State Department held. This was an exchange where Mr. Elsner was trying to get from the US State Department representative or spokesperson an acceptance that genocide was happening in Rwanda at the time. And there was that decided reluctance to accept that genocide was happening. Here you see the exchange. Here, Elsner, how would you describe events taking place in Rwanda? Shelley, based on the evidence we have seen from observations on the ground, we have every reason to believe that acts of genocide have occurred in Rwanda. Elsner, what's the difference between acts of genocide and genocide? Shelley, well, I think you see here the hesitation and difficulty. Well, I think, there's a legal definition of this. Clearly not all killings that have taken place in Rwanda are killings which might apply to that label and so on and so forth. And then, Elsner, how many acts of genocide does it take to make genocide? Shelley, Alan, that's not just a question that I'm in a position to answer. So here we have this, subterfuge of what, well, please, I don't want to call it subterfuge. We had an excuse that we have a certain definition that constrains us from recognizing that what was going on was a genocide. Now, what's wrong with that definition? What is that definition? Now, let's look at it. That is legal definition. And that definition is a definition that tries to quantify genocide, the intent to commit genocide, in a matter of looking for a body of occurrences that you can say signals a substantial intent to destroy a group, instead of just an intent. And that difficulty started with the American statute called the Proxmire Act of 1988. Now, genocide, the Convention Against Genocide adopted in 1948, and the US did not ratify that or domesticate it for 40 years. It was only in 1988, following the persistent insistence of Senator Proxmire, that the US needed to ratify that treaty and also domesticate it. So the US finally in 1988 said, okay, we'll do that. But then in doing it, here's the act called the Proxmire Act. This act may be cited as the Genocide Convention Implementation Act of 1987, the Proxmire Act. And what do we see there? Sorry, again, all these things you're seeing wasn't supposed to be that way. The transition is because of the movement of conversion of from what I used to do it and where it is now. Now, we have up on screen two instruments of interest to us. On the left is the Convention Against Genocide, and then on the right is the Proxmire Act. And look at the different definitions we see there. In the Convention Against Genocide International one, it said, in the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnic, racial, religious group as such. Now, the proximate act on this part says, well, whoever, whether in time of peace or in time of war, in a circumstance described in subsection D, and with a specific intent to destroy in whole or in substantial part. So the genocide, the Convention Against Genocide just leaves it simply as destroy a group, intent to destroy a group in whole or in part. But the Proximate Act tells us what it has to be intent to destroy the group in whole or in substantial part. That qualifier, substantial, is not in the Convention Against Genocide. And you ask yourself, is it too difficult for the drafters to have put that word in there if that was to be the controlling terminology in the genocide discourse? Substantial. They could have put it in there, but they did not. But the US drafters thought it important enough to put in their own statute. Why is that? We may speculate, but perhaps an explanation might be what Robert H. Jackson, my hero, by the way, in international law, observed in 1945 during the London Conference, when he said, well, we have had some regrettable circumstances at times in our own country, in the United States, in which minorities are unfairly treated. Well, does that explain why you might be more cautious in what you may label as genocide? There's a sensitivity or sensibility that's peculiar to you. It's not for us to wonder about that. But the important thing, as I say, is to return to the definition we have in the Convention Against Genocide and actually stop to think, what is the purpose of that convention? We see it in Article 1. The purpose of the convention is a dual-purpose convention, broadly speaking. The contracting parties confirm that genocide, whether committed in time of peace or in war, is a crime under international law which they undertake to prevent and punish. So we have the intention or the purpose of prevention, of the preventive purpose, as well as the punitive purpose, the purpose of punishing those who would commit the genocide. And then you have the definition of genocide in Article 2. Now, I have color-coded those two themes. The punitive purposes you see in the broad wash in light green, provisions that deal with that, but we still do have in pink the elements of the convention that deals with prevention. And there it says any contracting party may call upon the competent organs of the United Nations to take such actions under the Charter of the UN as they consider appropriate for the prevention and suppression of acts of genocide or any of the other enumerated acts. So we're not only focused on punishment, but perhaps people may say more importantly prevention, because people will feel better if the genocide didn't happen, or if it is stopped from happening, rather than wait until it happens to their relatives and all that, and then the culprits are punished later on. Prevent it first and worry about punishment later. Now, we have seen in the nature of things that the presence of mechanisms, punitive mechanisms in international law have dominated the discourse. We had the Rwanda tribunal, where I used to work as a prosecutor, defined genocide and punished a lot of people for that, and used the definition in the Convention Against Genocide, the same definition we have, basically cut and paste into the statute of the ICTR. The same with the former Yugoslavia tribunal statute, again, cut and paste the definition into the statute of the ICTY. And the ICC, the Rome statute, again, has the same definition, and none of these do we have that qualify as substantial in part. Now, how do we prove genocidal intent? This is important because it tells us what we do with what we mean by intent to destroy a group in whole or in part. Proving genocidal intent, that intent to destroy a group in whole or in part, how do you do that? Or what is it all about? We have cases out of the ICTR. The most case law in international law on genocide will come from the work of International Criminal Tribunal for Rwanda. And in one of those cases, the appeals chamber in the Gachambitsi case, that tells us, well, by its nature, intent is not usually susceptible to direct proof. Only the accused person himself has first-hand knowledge of his own mental state, and he is unlikely to testify to his own genocidal intent. Therefore, intent must usually be inferred. So there is no art to see the mind's construction in the face. And then, so you can't hope readily to get evidence of the mental state of the perpetrator. You have to infer it. But then a related question, but what is it all about in the end? This whole business of prevention and punishment of genocide. As that song is all about the base, but we can change that. It's all about the group. It's all about the group. The first case on genocide, international law case on genocide, the IAGS case, tells us that. In that case, the ICTR trial chamber tells us that the act looking at a genocide as qualifying as an act of genocide must have been committed against one or several individuals, because such individual or individuals were members of a specific group, and specifically because they belonged to this group. Continuing, thus the victim is chosen not because of his or her own individual identity, but because of his or her own membership of a protected group, national, ethnic, racial, or religious group. Therefore, this means that the victim of the crime of genocide is the group itself, and not only the individual. And so, that's what I mean by it's all about the group. And Accuser tells us that an act of genocide against one individual can qualify as genocide, an act of genocide. Because you're not looking at the individual. Why was this individual killed? Because that it could be anybody within that group. It's not about that individual. So it's about the group. And in trying to assess that genocidal intent, the intent to destroy the group in whole or in part, the case law of ICTR tells us that we don't go for the numeric approach. There is no numeric threshold we need to be worried about, or we need to be worrying ourselves about. And the Bohemana case says that plainly. The chamber notes that the phrase destroying in whole or in part an ethnic group does not imply a numeric approach. Right? But then the chamber goes on to infuse this osmosis of substantial group that needs to be, you need to see a substantial part target. And the same theme repeats in by the appeals chamber in the Bagosora case. Although there is no numeric threshold, the perpetrator must act with intent to destroy at least a substantial part of the group. That's the problem there. Substantial part of the group. Where do we get that from? Again, back to Gachambitsi, there is no, as I say, no art to find the mind's construction of the face, said Shakespeare. And Gachambitsi, again, remember that only the accused knows his own or her own mind or mental state. But now we see this exogenous intrusion of the concept of substantial part into the thinking of what should amount to intent to destroy a group in part. Exogenous in the sense that it is not a term we find in the Convention Against Genocide itself. It does not say intent to destroy a group in substantial part, simply says intent to destroy a group in part. But case law has been influenced by the American Proximate Act insertion of substantial in there, and everybody now in the international criminal law jurisprudence is now embracing that as the way to go. And you see the difficulty with that unfold itself in the Mlandich case that was decided, was that a year or two ago, I think it was last year, by the appeals chamber of the IC, of the residual mechanisms for the international tribunals. I call that the description of a numeric threshold. Yes, so we're not going to worry about threshold, say the previous case law. And in the same Mlandich judgment, they still say, we're not going to worry about threshold, but what do they do? Here, the appeals chamber talks about, as recalled above, where a conviction for genocide relies on intent to destroy a protected group in part, the targeted group must be a substantial part of the group. And he goes down further and observes that having taken, stock of the evidence of what happened in the Bosnia-Herzegovina part of Yugoslavia as it was then, that the number of, let me read out here, paragraph 589 is better, let me quote that. The appeals chamber recalls, however, that its substantiality assessment considers the impact that the destruction of the targeted group will have on the overall survival of the group, noting that count one communities collectively comprised approximately 6.7% of the Bosnian Muslim group. The appeals chamber considers that a reasonable trial of fact could reasonably have concluded that the count one communities individually as well as cumulatively form a relatively small part thereof. The appeals chamber therefore concludes that a reasonable trial of fact could also have found that the destruction of the count one communities individually as well as collectively was not sufficiently substantial to have had an impact on the group's overall survival at the relevant time. In other words, 6.7% did not amount to substantial part of a group. And I say that is legal reasoning, quite frankly, derailed, in my humble opinion. There were two judges out of the five who dissented from that finding. The judges, Aminata Ngom and Judge Seymour Panton, disagreed. They found that there was a substantial part. The difficulty I have, I can relate to where they're going. My difficulty with them, with that reasoning, even that, is that they try to make substantial part wide. They say, well, yeah, it is substantial. Whereas my view is that we should ignore that bit about substantial. It is not part of the genocide, of Convention Against Genocide. Nevertheless, I want to note that they dissented from the appeals chamber's reasoning. Now, let's look at, when I say that was derailed legal reasoning, to say that 6.7% of the population didn't account for substantial part, let's look at what this really means in real terms. Liechtenstein, for instance, a country of 40,000 people, 6.7% would be 2,600 of individuals in that country. Nigeria, my native country of 223 million people, 6.7% would mean 14, or rather 15 million people. USA, country of 234 million people, 6.7% will leave 22 million people. And India, country of 1.4 billion people, 6.7% translates to 95 million people. That is what Mladic judgment is telling us. Sorry, those will be a small part of the population. 95 million people in any country. I don't care whether it is 2 trillion people, 95 million people is a lot of human beings. And anyone who targets those for killing, in my view, I find it difficult to say, well, we cannot call that intent to commit genocide. So here the point is, all we've seen that's driving that conception of genocide is to look at it exclusively from the punitive perspective, so as to be keen, to not be seen, to be anxious, to punish people. I understand that. I used to be a judge at the ICC. You want to be sure that, that there's proof beyond reasonable doubt before you can send somebody to jail for anything. And also, if you can use a normative approach to making sure you really, really are sure whoever you're punishing deserves that punishment, so be it. But it should not elide the normative, compelling duty of state to prevent genocide. Whether or not there's punishment at the end of it, the primary, in my view, purpose should be to prevent genocide from happening to begin with. And it's very difficult to say, yes, we can do that prevention job enough or at all if we waited to see that we have compelling evidence beyond reasonable doubt that the perpetrator actually intended to destroy a substantial part of the group before we can spring into action to prevent genocide from happening. You have to wait until the act of genocide has concluded for you to form that kind of impression. It becomes a virtual impossibility, in my view, in the order of the need to prevent genocide. Now, I don't need to take you back to the Convention Against Genocide, how it makes that point that prevention is one of the 2 objectives of the Convention itself. But the ICJ itself, in the 2007 judgment in the case concerning the application of the Genocide Convention, Bosnia and Herzegovina versus Serbia and Montenegro. Although there are parts of reasoning that are questionable in the terms of the numbers of people who were killed and whether that would amount to genocide. Nevertheless, the ICJ did leave us in that judgment some useful foods for thought about what we are doing with the Convention Against Genocide and what we should be thinking that convention is supposed to do. And in it, the ICJ stressed the point that, yes, we can see from the convention that purpose of punishment is big in it, all well and good, but that cannot overcrowd or overshadow the fact that the convention itself also intends to prevent the commission of genocide. So member states to the convention must resolve themselves to their obligation to prevent genocide as much as they have an obligation to punish genocide that could not be prevented. So we go back to the, I'm going to close by harking back to that debate we had, or that was happening between Ms. Shelley and Mr. Rasner in June 1994. That difficulty in saying, why are we not seeing America do something here? And that difficulty of, well, there is a certain definition And that definition requires us to see that there is an intent to destroy a substantial part of the group. That prevented the international community from doing that preventive function that it should have done when that genocide was happening, only to acknowledge it 4 years later. We should have done better. If we don't regroup our thoughts and revisit this concept of substantial part, we are going to have that problem again, the next genocide, because we have not seen the substantial intent in the minds of those who are committing systematically certain acts of violence against a group that they should not have committed. So I will leave it at that and say, let's think again about the substantial group. Thank you very much.
Thank you very much, Judge. It's always interesting to look at the, probably one of the hardest part of the definition, of the legal definition of genocide, let's say. We do have a few minutes left if anybody wants to make a question to the judge or comment. Yes, Sheila. Hold on. Tenim micro, Sergi? Yeah, hold on, Sheila. Just gonna bring the micro. Okay, then you, okay. Let's start with her. She asks first, and then we go with the other two.
Thank you. You can hear me? Thank you, Chile. You brought me back to my former career. I actually had the privilege of working on the Mladic appeal judgment. And it wasn't the first time that the ICTY or the mechanism had determined that the intent should be in whole or substantial part. That was based on prior jurisprudence. And you know, I know that it's controversial, but the Mladic Appeals Chamber was bound by the prior jurisprudence on the issue. I think the Krstic appeal judgment had already determined it. So just to, I know that you don't have enough time to go through all the jurisprudence, but I did want to put that in there. That's about all I wanted to say, other than as touchy of an issue as it is, especially for me, when it comes to, you know, especially in diaspora groups or groups that are spread across the globe, the whole, or throughout different countries, to target a group within a certain country when there are remaining, let's say in the case of Armenians, there weren't just Armenians, there aren't just Armenians in Azerbaijan, or, you know, what's now considered Azerbaijan, or in Eastern Armenia, Eastern Turkey, to say that, you know, do we limit the group within a geographical border and then count from those borders, or do we look at the group as it's spread out all across the world? I don't have an answer to that, but I think that those situations are where it gets very easy to politicize the whole or in part question, because if there's a substantial part of the overall global group, and then you just kill them all in one place, does it count as genocide or not? I would say, of course it does, but that was just my little comment.
Okay. Should we collect a few more?
Sure, we can collect then. But Sheila, the appeals chamber was not bound by previous jurisprudence. The trial judges were Gutenberg could have
they could
corrected
have changed,
it.
yeah,
Yes.
Mladic could have changed, but Mladic didn't start it. Let's just put it that way.
Okay, on the back first, they had.
My question is general. You spoke about the statistics on the people who will be able or may act genocidal acts from the population statistics. Is there any statistic run by you? How many genocides had been prevented since the adoption of the Genocide Convention for Prevention and Punishment for Genocide after 1948? As I don't know any. The second question is, what has the UN High Commissioner for Refugees and the High Commissioner for human rights did during the Nagorno-Karabakh conflict and the war in Nagorno-Karabakh? And what is the reason why two organizations are not so active in this case, in the case of Armenians? We know all very well that the United Nations High Commissioner for Refugees was mainly and partly established by the Treaty of Nansen, was very active after the Armenian genocide, for making the history publicly known and for saving the refugees and victims from further annihilation and assimilation. So it's actually I had two questions, and I would appreciate if you can answer for both of them. Thank you.
So, thank you. I have a question, and that's related to the Gambia versus Myanmar case. During the provisional measures hearing, there's a question raised by one of the counsels, and that's about the intention, because the counsel raised that since there's a case before the ICC relating the crime extermination of deportation, so that can negate the intention, genocidal intention. But if you see or revisit the jurisprudence of ICTY and ICTR, there is a concept of cumulative conviction, and that arose out of those statutes. But my question is, to what extent the concept of cumulative conviction that may be useful for in the married state, I believe, is reflects the status of international law or customary or conventional. Thank you.
Yeah, let me hear.
Let's get some answer and then we collect again. We do have time.
All right, thank you very much. Is this working?
Is it? Yeah.
Thank you. Let me start with the last question about cumulative conviction, so I explain what it means. So it's basically, because not everyone in the room is an international criminal lawyer, it would mean where you have one act, and that act could amount to different crimes. You can charge only one of those other crimes in relation to that act, but then somebody will say, well, it's not enough to charge this person for only one crime out of this act. Since there are other crimes that can be charged on that act, we're going to charge those as well and convict them. So that is the concept of cumulative conviction. And it does have a purpose in international law. The idea, let's say, somebody goes to a place and targets a group and kills them all, or attempts to kill them all. It could be an ethnic group, a racial group. Now, that can be, if it's in the context of a war, could be a war crime if it was soldiers that did that. It can also be a crime against humanity, extermination against the same soldiers who did that. You can charge for war crimes alone, or war crime and crimes against humanity. But you could also charge for a crime of genocide if you could find the intent to destroy the group in whole or in part. Those three crimes tell, normatively speaking, different stories, so to speak. The people who have been targeted for destruction will say it is not enough to say this was a war crime, because these people are meant to wipe us out as a group. We would like to see that acknowledged normatively. So you can see the value for that. So yes, indeed, cumulative conviction is a feature of international criminal law, and there is merit to it. The question rather would be, how much punishment can you impose upon a convicted person without, some would say, trying to trivialize criminal law in a sense. For example, there are some jurisdictions, I need not name them, where they would do cumulative conviction and say, well, we are going to sentence the convicted person to 500 years in prison, all right. What does it tell us? 500 years. Are you gonna, if somebody who's 50 years old or even 18 years old gonna live 500 years? So that becomes an issue. But yeah, there is merit to, in my view, cumulative conviction in international law that account for genocide in addition to other crimes that the same act may also account for. Now, working backwards, the question the gentleman asked me, two questions, and I'll take them in reverse order for easy of answering. And the easiest one to answer is, why is the UN or international organizations not doing more to recognize the Nagorno-Karabakh, what's happening there? That's an easy one to answer, not because the answer is a good one. It's not. Easy in the sense that I could not account for what is in the minds of the international, those organizations you're talking about, the UN. I could have explained why they're not doing it. But what I will say to people is, those who care for that issue should not stop because they don't see movement from the international community. I do believe that people who believe that they've been victims of atrocity need to dig in and speak about it and urge the world to do something about it. Somebody asked me after lunch today, again, not wanting to embarrass whoever it is, said, well, our group, is there hope for us in what we're seeking to achieve? I told that, in my humble, respectful view, that's the wrong question to ask. To say, is there hope for what we are seeking to achieve? The question, in my view, if I were in that position, and I have been in that kind of position on other things, the question would be, do you have a choice in what you must do? That's what must guide your action, and not whether somebody else react the way you want them to react. You want them to react a certain way, but because this is an important cause, you must keep at it and not shortchange yourself or second guess yourself. I say, well, I'm not going to even bother because what's the point? Are they going to react? I would say, go for it. And it's up on that the failure to do something be on the other person and not on you for not trying, not doing all you can. So that's my answer to the second of your questions. The first one would be, how many genocides have been prevented by the adoption of the Convention Against Genocide? When you asked that question, I couldn't help but detect some sort of chuckles in the room. They might have muffled chuckles, but that is an old question that you encounter in different ways about the value or purpose of international law, international criminal law in particular. International criminal law in particular. When I was the president of the ICC, I got that question all the time. Well, what value has international law given? And I asked people, okay, let's change that question. And I'll change that even to you. How many murders have been prevented by your criminal codes? Every one of us comes here from a country with criminal codes where murder is a crime. How many murders have been prevented by our criminal codes? How many rapes have been prevented by our criminal codes? And rapes are a big no-no in criminal law. How many thefts have been prevented by our criminal code? We should ask the same question before we look at international criminal law in that way. So international law is not the answer to how we must behave as human beings, nor is criminal law the answer to how we must behave in society. What they do is to say, well, to the extent that we are not, again, I made this point in a small group where we were before now. I think what criminal law does is to say, well, because people have not behaved the way they should behave, left on their own without strong legal intervention, therefore strong legal intervention comes in hopes that somebody may be punished, at least for some of these crimes. And that is why we have criminal law. So it is with national criminal law, so it is with international criminal law. Thank you.
We still have more time. Yeah, you were on the waiting. Monica, thank you for being an assistant, spontaneous assistant. And then
Thank you very much, Marco Longobardo, University of Westminster. At the risk of spoiling my presentation in a couple of days, I wanted to ask your opinion on this constant lack of attention to the legal content of prevention. You mentioned the ICJ Bosnia versus Serbia case. It always puzzled me that the court said the state is responsible for lack of prevention if and only if the genocide in fact occurs. Whereas the duty to prevent genocide is described by the court as a due diligence obligation of conduct. So we should not care whether at the end the result occurs or not, the genocide occurs or not. We should just try to stress the states have duty to act diligently to prevent that event. Also because measuring negative events, as in the last question, is impossible. Many lives have been saved by the COVID vaccine. We cannot measure that. But I wanted your opinion. That part of that judgment, that it has in a certain way brought back the need of a genocide to assess prevention. Thanks.
in front of you, Armin.
This relates to a point that Sheila brought up earlier with regard to your points about substantial part and location, geographic location. And I want you to tie it to the question of denial, because I think what this introduction of substantial part can be used by those who deny genocide. We see that with the Holocaust because of the claim that, well, there are Jews around the world, and what happened in Europe is exaggerated. And we see it in other cases where survivor groups then are used as evidence for the fact that genocide has not taken place.
Okay, there's one more question. Yeah, over the back. Okay, vale, Monica. To him and then to her. Yeah, let's see if we can.
Thank you. I want to ask you who had the power or authority to declare an action or an act of an individual or a group a genocide. Apart from that, looking at the percentage, 6.7% that you presented this evening, my mind goes to what is going on in Ukraine, between Ukraine and Russia. With the kind of death that the war between Russia and Ukraine has produced, can we declare the act of Putin as an act of genocide?
Yeah. Well, the matter of who has the power to declare conduct as genocide depends on at what point we are taking account of that conduct. It also raises a question about our own participation in society and our own agency about getting the formal leaders of societies to do something. So before you get to the courtroom, let me put it this way. In the context of a case before a court, it's obviously the judges who would make that pronouncement for purposes of punishment. Say somebody is convicted for genocide and punished for it would be function of judges. But before a case gets to court, or for cases that don't get to court because the genocide has been prevented or arrested in its tracks, all of us in this room, all of us as members of society, do have the agency to call out what is happening, at least for purposes of discussion, at least for purposes of inspiring leaders to do the right thing. Now, luckily, for that discussion is not unguided, in the sense that we all get up and say what we like about a certain situation. It is guided by a convention that has set out the parameters against which conduct may be assessed for what they are worth in any discourse on whether or not genocide is taking place. So we do have the power ourselves to make observations as to what's happening. That observation will not convict anyone, but it will inspire leaders at their own level to do something about what's going. In other words, try and prevent genocide from happening, or stop the genocide that is happening from continuing. So there is no, I would say, vacuum of agency in making that kind of determination. It depends on where it is being made in what forum. The two other questions are more remarks with which I agree than questions really, and Armin's point about that intrusive, should we say, importation of substantial into the definition gives deniers an excuse to do so, and that's absolutely right. And it gives the deniers that excuse where they now have a legal basis to do so, because we see case law of ICTY, ICTR, or definition of genocide in the Proxima Act. So we do not accept that what happened was genocide because we don't agree. We can quibble about was 6.7% a substantial part, or 2% a substantial part, or is even 10% a substantial part. So where does it engage to become substantial? So you saw the early case law of the ICTR, saw that conundrum, and tried to avoid it by saying, well, we don't want to be identifying any numeric threshold. But then they undid all of that by saying, but it still must be substantial. Why? You don't want a numeric threshold. How do you assess then when the thing gets a substantial part? That's why, in my view, it is, quite frankly, the wild goose chase that's a very dangerous one. Not just wild goose chase that we can laugh about. It is dangerous. And your question again about the lack of content to the preventive purpose. Why? Again, the best I can do is to say, well, maybe because the punitive approach might have got ahead of everything else, with the ICTR doing its work, ICTY coming in, and that reluctance to punish people, understandably so, unless there is proof, as we say in criminal law, beyond reasonable doubt that somebody has done the criminal act. We don't want to be seen to be punishing them. That may well be what, in my view, distorted that discussion, and it is a distortion to the extent that we are focusing only on the punitive purpose of the Convention Against Genocide to the detriment of the preventing purpose. It is a distortion. Both need to come together, and I do believe that we can start somewhere. This conference now have decided to devote attention to that question. Is it the right approach to interpretation of the Convention Against Genocide? If we all see the point, then the next time we engage it, we say, come on guys, let's think about all this stuff, and hopefully we can manage to bring up the preventive purpose as well.
Okay, maybe we can just take a couple of questions that were Monica in front of you, and then over there, and you, and then we're done. Please be brief.
Thank you.
Yeah, thank you.
Yeah, proving genocidal intent is not easy, as I noticed. Meaning it must be inferred, as you said. But tracing this intent means tracing different intervention and act through speech, through writings, or through different intervention and act. It means it's collective by nature. Do you think the way intent is understood today, is it possible to find an individual responsibility of intent in justice? Do you think, is it possible to convict someone as an individual the crime of intent? Yeah, this is my question.
Thank you.
Yeah, over there.
Thank you. In part, the previous question set up my question, which is, I detect that you're displeased with where international law has led us on this issue, but what are the alternatives in a court of law, under the laws that we have, to prosecute someone for genocide crimes? And I know you were at the ICTR during the Eboe-Osuji trial. It's very clear that the court wanted that trial to be found guilty, wanted Eboe-Osuji to be found guilty of genocide crimes. It was relatively easy compared to many other cases before the court because it was a circumscribed geographic area. There was lots of documentation. Later decisions of the ICTR, if you look at the decisions, more and more the judges find people guilty of war crimes, and almost more and more rarely over time, crimes of genocide. So I just want to see, what are the other options besides where international law has gone to prosecute crimes of genocide?
Should I?
So there's one more, and that's it. Yeah. Monica, yeah, here in front. Thank you very much, Monica.
Thank you so much for your presentation. I have two questions, specific two questions. One is regarding intent, and another one is regarding the distinction, the debate between actual genocide and genocide. So you refer to Gakumbisti case where ICTR suggested that intent must be inferred. So assuming that perpetrators and victims, they must stand on an equal basis in a criminal trial, do you think that the group identity should also be inferred? Because whether I belong to a particular group, whether it's a matter of psychological state of mind, or it's a visible representation, how I represent myself as a part of the group. So what's your opinion on this point? And I think regarding also this statement between Christine Shelley and Alan Elsner with regard to actual genocide and genocide, you talked about prevention. So you also referred to Genocide Convention. And I have found that while talking about prevention of not genocide, but acts of genocide, the UN Convention was drafted in a way that it will wait until a genocide has been committed and someone like a trial will consider it as genocide, then they will talk about prevention. Because I think Article 3 or 4, it talked about any contracting party may call the United States, the competent organ, to prevent acts of genocide, not genocide. So why was it so? Why they use the acts of genocide, not genocide specifically? Thank you.
Okay, thank you.
Okay. Thank you very much. I'll begin in the order in questions were asked. And the question that tracing genocidal intent is difficult, and you ask whether it is even possible to convict on the basis of what in law we call circumstantial evidence, or what somebody had given somewhere, their conduct in real time or even before, looking at the pattern of offense that you are seeing systematically, that the killing was not random, as in coming and somebody's, killing anybody that they see, but you look at it is members of a certain group that are being targeted. All these things come together in what we call circumstantial evidence in the case. And yes, it is possible, and yes, in almost all the cases, and that comes back to a question from out there, actually, I can't remember, Chile, you're here, whether there's any ICTR case that did not have a genocide conviction. All right. Yes, I mean, Chile used to work with me on the ICTR in those days. Almost all the cases of the International Criminal Tribunal for Rwanda convicted the accused persons of genocide, and it is mostly on this basis of circumstantial evidence of what people said. They may not have said, in some instances, they would join groups that would be singing Tubats and Betsembe, let's exterminate them, stuff like that. You could have that, but if you do not see the accused person as part of that group, but the accused person somehow has a certain connection to the people singing, chanting that stuff and other things. So yes, the ICTR did convict very many people of genocide. And it was based on whether or not people will say, well, Akiyezu started, and now I'm segueing into your question, at first with a conviction for genocide in the Akiyezu case. That was a case where I said, at a point where I said, it's all about the base, it's all about the group. The Akiyezu case stressed that the victim of genocide or victims of genocide are not the individuals who have been killed in the act. Of course, we cannot ignore the victimhood of the individuals who were killed, but then the ultimate victims of genocide would be the group to which the victims belonged, because it could be anybody within the group who would have fallen victim. In law, we talk about what you call, fungible things you can replace without changing the nature of the thing or the nature of the enterprise. So human beings then become fungible objects in this enterprise of genocide, in the sense that you're targeting somebody. Well, yes, you've killed A because a member of the group, but if A wasn't there and it was C that was there at that time, you would have killed C because it's a member of the group. So it's not about A or C, it's about the group to which they belong. And the Akiyezu case tells us that you do that with one person because of their group, and it is a group. So yes, indeed, you can be convicted of genocide. So whether or not later on the ICTR brought in this substantial test without really measuring it, which tells us, well, how do you say substantial when you don't measure it? How do we know when you're not convicting on the basis of one person was killed or two persons was killed versus a substantial part was killed? So in a sense, one may say it was pointless exercise to stress that substantiality part in the jurisprudence of ICTR in particular, up until the Christchurch case, where we see the value given to it was in Mladic case, but then that value indicated why it should be wrong to stress substantiality, because they tried to give oomph to substantial part. But then you saw the result, that 6.7% could not be a substantial part of the group. So, I mean, there you have it. But your point that convictions of genocide, the numbers may not be as much as what we may think. It's more with ICTY cases than ICTR cases. In the ICTY, that's the Yugoslavia case, there was more emphasis, so to speak, driven by, perhaps by the typology of the conduct in question. You had more war crimes convictions at the ICTY, International Criminal Tribunal for the former Yugoslavia, and you didn't have as much war crimes in the International Criminal Tribunal for Rwanda. You had more genocide convictions in Rwanda and more war crimes convictions in the ICTY work. I think, yeah, and there's one more question about acts of genocide versus the intent. I missed that. Can you repeat that question again, please, if you don't mind?
Well, I mean, if you draw your attention to Article 8 of the Genocide Convention,
yes.
So it talks about prevention of acts of genocide. So it's not saying genocide.
Oh,
acts of genocide.
yes. Thank you. Thanks for reminding me. The point there was that I'm not sure that the focused intent, or that the drafters of the Convention Against Genocide meant to say, well, we're going to focus on acts of genocide and not in the prevention part. When you see that definition of acts of genocide, sometimes in legal drafting, there's a way you draft, you do legal drafting and you confuse everybody, even yourself, as you're trying to draft. So oftentimes when you want to say, okay, I want to give a definition, and in that definition I want to have a sentence that captures the definition, but then as you're drafting that sentence, you see that you're packing in a lot of things, a lot of qualifiers, a lot of elements in the definition. So by the time you finish, you don't know where you started and where you ended, and let alone the reader. So at some point you have to break it up and say, all right, look, we need to for this thing to make sense, it will be a logistics of drafting. We're going to break it up and then account for some of these things we can have packed in over there, but then that will have overloaded the drafting. So we're going to remove them and put them somewhere else, and then streamline the first part of the definition and make a linkage to the second part. That's my view of why Article 2 of the Convention Against Genocide was drafted the way it was. Not because they wanted to emphasize that certain things counted and others didn't, and we're going to account for that. To an extent, yes, but not in the sense of the prevention of genocide. I think that I don't share the reading that for you to prevent acts of genocide, that the drafters wanted you to wait until the whole thing has calmed down before you can prevent. I don't see what point is about prevention in that way, unless you say, well, yes, we want to wait, and then in future another one, we want to make sure people don't do the same thing. But then that doesn't help the victims of the first experience. So I wouldn't read the Convention Against Genocide in that way. Thank you very much.
Well, thank you very much. Yeah, I can do an applause.